Hi there, this is on Subrogation, and today our topic is product recall notices and how they can help you in a product's liability case. As you know, a product recall is a request from manufacturers who have put products into the stream of commerce for the consumers who have purchased that product to take a certain action, usually because of the discovery of some sort of safety defect or a performance defect with the product. In some cases, this request involves taking the product back into the manufacturer so they can make repairs. In other cases, this involves taking the product and disposing of it because it's too dangerous. In certain circumstances, you can think of in the case of food, for example, if there is food out in the marketplace that has salmonella or some other infectious disease, they're going to ask you to just throw that away and make sure that you don't bring it back to the store. Now, in subrogation cases where your damages have been caused by a defective product, that product recall that was issued by the manufacturer can actually come in and help your case in certain circumstances. There are certain evidentiary rules that may limit the effect that you can bring in the product recall, and in certain cases may actually prevent you from bringing the product recall in at all, and we're going to talk about those. When it comes to product liability cases, there are a certain number of things that a plaintiff will have to prove. And in subrogation cases, you're going to have to prove that there was a product that caused you to be injured. The product that injured you was defective at the time it left the hands of the manufacturer. The defect in that product is what caused your injury, and that you were using the product in the way that it was designed, or basically the way that you were supposed to use it. You weren't deviating from the intended use. These sorts of categories can be grouped into a number of areas. Number one, if there was a defective design of the product, you can sue the manufacturer for that defective design. You say that the design of the product was defective. It could have been designed in a better way, and the defective design is what led to your injuries. You can also see a group of cases where there's a product that's manufactured in such a way that it deviated from the intended design that increased the risk to consumers. So the design is fine, but the actual production of that design was a failure. And then there's also cases where the manufacturer has ignored or failed to warn about certain risks with the use of a product. So if there's a foreseeable risk that a product will be used in a certain way, and that way of using the product is dangerous to consumers or poses a hazard, and they know about this and don't tell people, that's also a form of product defect case. And as you know, in all product liability cases, a plaintiff can sue for the financial and non-financial losses that they suffered as the basis of their case. This can include injury or illness, lost income, and as well as pain and suffering if the person is injured. Now, some product defect cases only affect one unit. So you can see about if there's a vehicle that was purchased and it has a very specific defect to that vehicle, that is a one unit product defect, and you're probably not going to see a recall on that unit. However, since a lot of the products in the stream of commerce are mass produced, or they're using component parts that are themselves mass produced, you're going to see a whole lot of products where every single product in that line has the same defect because they were all produced the same way or with the same component part, which may or may not have that defect in it. So if you have a defect that includes every unit of a single product, you will usually see product recalls if the manufacturer knows about this and those products are out there. Now, if a product manufacturer knows that there is a product defect in something that they've put out into the stream of commerce, they may proactively issue a notice of that product recall to their consumers, or they may be asked to do so by a government agency like the Consumer Product Safety Commission. Notices are typically sent just by mail to the directly affected customers. Notices can also be sent out to all the distributors and sellers so that they can make their customers aware of the product defect, as well as all the purchasers that they can come up with to whatever extent that's possible. Notices can also be published online. Typically a manufacturer that has a large number of products that are subject to a recall may put something on their website. They can also be put in trade journals. It can be published to the general media, and the government may actually get involved and publish their own recall notices saying to take this product in. When a product manufacturer can prove that it sent a notice to the insured, a lot of cases will see the product manufacturer try to use that to their benefit to say that the insured or the consumer was negligent in some way. So they'll say, this product was defective. We sent this notice out. We can prove that we sent it to the consumer at this address. In certain cases, they may be able to prove that the consumer received it. If the consumer comes out and testifies, yes, I received the product recall notice, that would be one way of showing that they got the notice. A manufacturer may then expand on that argument to say the consumer had the notice, they knew that this product that they had in their possession was defective, and yet they continued to use it rather than abide by the recall. Their argument is going to be that the insured or the product consumer is going to be somewhat negligent in some way, either contributory negligence or just they were using the product incorrectly. However, the confirmed receipt of a recall notice does not actually extinguish your subrogation claim. A lot of times the insured may ignore the notice or they may never receive the notice. That doesn't necessarily make the insured's negligent for whatever damages result from the use of this product. But even if there is no dispute, as I mentioned before, if there is no dispute as to whether or not the recall notice was issued and whether or not the insured received it, the manufacturer still must show that the recall would have been effective in curing the defect that it was sought to address. So that specific recall notice would have had to have cured whatever it is that eventually goes wrong with the product, whether it be a fire or, in the case of plumbing, a flood, something like that. Now, when it comes to the injured party, so in subrogation cases, we're talking about the insured, many courts have admitted the recall notice into evidence to show that a particular defect existed at the time the product left the manufacturer's control. And as we mentioned earlier in the video, that's really one of the main things that you're going to need to prove, that the product was defective and that it left the manufacturer's control when it was in fact defective. The plaintiff must show substantial independent evidence of the defect's occurrence in the actual product in their case. Now, if you have a letter from the manufacturer that says, this is our product and it is defective, you've already gone a long way towards proving your product defect case. Now, one way that a product manufacturer may try to fight you on introducing a recall notice as evidence is by calling it a subsequent remedial measure, which is barred from evidence under the federal rules of evidence. In subsequent remedial measures, when a product manufacturer subsequently comes along and does something to correct a defect in a product, that correction will be inadmissible to prove negligence, culpability, or the existence of a defect under Federal Rule 407. Now, although they are inadmissible for certain purposes, that same document can be admissible for other purposes. So you can't bring in the product recall notice and say that this proves negligence, culpability, or the existence of the defect enough to establish your product liability case. However, you can bring it in, number one, to show that the company at issue owned that product. You can also bring it in to show other certain things, such as the manufacturer is aware of this issue. One thing to look out for also in this area is that if the product recall is compelled to go out by the government, a lot of times the subsequent remedial measure rule will not be allowed to be used, because the whole purpose behind the subsequent remedial measure rule in evidence is you want companies to take their own initiative and do the right thing. Whereas if you have the government forcing them to do the right thing, they don't get the protection of that rule if they basically had to be told to do this. Some states, the rules of evidence actually make recall notices expressly admissible. Other states, it's either by rule or case law, and you have to make a showing that this is either a subsequent remedial measure or not. One state, the state of Rhode Island, makes the evidence of subsequent remedial measures specifically admissible. So if you're in Rhode Island, that recall notice will come in. So we've talked about product recall notices and how those affect a product liability case. However, I would caution you that in most cases of product liability, the product recall notice is not going to be enough to win a case in litigation, certainly, but it also might not be enough on its own to get the case resolved. In most cases of a product liability or something that has to do with a fire or a flood like this, the opposing side, that is the manufacturer or their carrier, is going to want to see the evidence, not just the product recall. They're going to want to see whatever the scene looks like where this danger occurred. They're going to want to see expert reports. You still have to prove up the rest of your case. You have to show that the fire or flood or whatever it was, the damage was caused from the defect, and you're most likely going to have a scientific basis for that. And just one recall notice on a piece of paper is not going to get you there. You're still going to have to go through, in certain cases, setting up evidence inspections, the whole piece of it where you have to preserve evidence, send notices. A lot of that stuff's still going to have to be done, but that recall notice is going to be very clutch in proving your case down the road. If you have any other questions about product defect cases or product liability, please contact us at info@rathbonegroup.com, and make sure to like and subscribe on YouTube or on our podcast, the On Subrogation podcast. I have been Steve, and this has been On Subrogation.